I believe we're live. There we go.
All right. Welcome to Keys from Home, Season 4, Episode what, Mark?
9. Episode 9.
Special guest Garrett Haynes is with us. He's an attorney. He's going to be talking to us in a little bit about wills, trusts, power of attorney, and other things. I don't think we're going to get deep into prenuptials and divorce stuff, but I think we need to have him back on that because it affects lending, budgeting, and finance planning and assets and buying houses. So hopefully we have a good run, and Garrett wants to come back and play with us again another day.
Thank you, Jennifer. I'm glad to be here.
For sure. So what's that, Mark? What have you seen this last week?
Well, we've got a lot going on in the personal finance space that's going to affect millions of people, millions of borrowers. The Eighth Circuit of Court of Appeals reversed and effectively ended the SAVE, which is the SAVE Student Loan Forgiveness Program. On March 9th, that was effectively ended. And that is affecting 7 million borrowers of student loans, which basically means there by July 1st, 2026, those that are in the SAVE Act, I was just looking for what SAVE actually stands for. Hold on just a second. It's the Saving on a Valuable Education Plan. What that's going to do is on July 1st, 2026, those in that program are going to have new repayment options. By July 1st, 2026, you're going to be transitioned into something called the RAP, Repayment Assistant Plan. And those payments will be 1 to 10% of a borrower's adjusted gross income. But forgiveness will require 30 years of payments, which is a significant increase from the 20 or 25-year terms under the previous plan. Additionally, sunset of older plans are going to be taking place. That the most existing income-driven plans like PAYE, and the ICR are being phased out and will be sunset on July 1st, 2028. So anyone that's listening to this right now, there's 7 million people that are in those programs. You need to contact your loan service provider of your student loan and start looking at what options you're going to have. I cannot stress this enough. Do not mess around with student loans. They are not kidding when it comes to repayment on student loans. More than likely, I don't want to be too direct here, you're not going to get out of paying your student loans. That's the most important and stress that I want to put on this. Okay, best thing to do is accept the fact that you've signed these loans, you're responsible for them, and it's time to look at how you're going to adjust to taking on these payments. I'm sorry
these are not bankruptable, are they? These are not something that people can declare bankruptcy on either, right?
No, student loans are not bankruptable.
That's what I
thought. Additionally, the penalties of avoiding your student loans are ramping up. I know of 2 states right now who are effectively taking away driver's license if you don't pay your student loans, and professional licenses if you're in default. They're ramping these up really hard, and so it's not something to joke around about. It's not something to bury your head in the sand on. And I know I'm being direct, but I need to be direct.
Yeah.
And that's the effectiveness of coaching.
Yeah. That's not a pretty conversation, but it's one, honestly, that scares a lot of people. So a lot of people are just like, I'm not even going to look down that road. But that's not people have been doing that for too long, and it's really going to come home.
Yeah, I think it's time to rip the Band-Aid off and explain to people, stop thinking that you're going to have someone else pay your student loans.
Yeah.
I'm sure I'm going to get a lot of blowback for this, but the fact of the matter is, why would you want a loan for 30 years? That's the equivalent of buying a house and the amount of interest that you're going to be paying. Stop messing around with it. Elevate and set yourself on an aggressive path to paying off debt. And I'd be more than happy to sit down and figure out a strategy with you through my company, Aspire Coaching, and let's figure out what we can do to get you out of this mess. By the way, I paid off $85,000 worth of student loans.
Yeah, so there's hope, and you know the path, and you can help people with it. On that happier note, Lance, what have you been seeing?
Well, Mark speaks the truth. It's interesting, the biggest personal debt in our country is mortgages. It's about $3.5 trillion, and right behind it is the $1.8 trillion in student loans. 48.3 million Americans have student loans. Think about that.
Ugh.
That's a big number. And you're talking about pushback and blowback a little bit, Mark. The biggest social media influencer ever, I'm going to go ahead and say it, was the White House during the last administration saying, hey, you don't have to pay these. You're forgiven. A single person standing at a podium saying it by executive order. But guess what? Got turned over yesterday, didn't it? By the courts. And we've already seen this. It's a mess. We have lots of applications coming in where people were like, I wasn't making payments and I didn't know. And I didn't know that this decision just happened, but people had to start paying things back. When was it, Mark? Because we did a call about this last year. You're like, hey, you need to start making your payments now. Everyone got notice. Well, we see a lot that didn't. And he said, Mark said, don't mess around with your student loans. Don't, because that's going to affect your credit score and your ability to buy a house more than anything else. It's not like making a phone call and saying, oh, I didn't know I need to start making payments. I'm 180 days behind. Can you go ahead and correct that? I didn't know. No, you needed to know. And I know that everyone on this go, at least Jennifer, myself, and Mark, when we're talking with people, we're like, hey, don't mess around with that, because it is the most serious thing. I, like you, Mark, paid off $85,000 in student loans in a year. I did it. And that's because of a person with the same name as the woman to the top left there, but who happens to be my wife, was like, you're going to do this. And we're not doing anything else until it's done. So it can happen. That was much like Mark. I mean, Mark, honestly, what did you do? You paid off 308. What was your big number in 62 months?
Paid off $323,501.21 in 5.5 years.
Yep, because you put your mind to it, and it can be done.
Yep.
What's going on, Jennifer? You said what else is going on? Rates are kind of getting back to where they were 2 weeks ago before this Middle East thing happened. Jennifer and I had a conversation earlier today about a different subject, but I said I was going to talk on this. If people are thinking about refinancing, and finally we're at that point where people can refinance and save a lot of money. I mean, we were in the mid fives last week on a 30-year fixed. On a lot of our customers that Jennifer and I closed just in the last year or two, the average rate was 6.5, 6.7. So dropping to a 5.5 on some of our Tennessee loan amounts, that's a couple $100 of savings a month. And so people kind of were dragging it along. And then guess what? They saw the news, war started, rates are up, and they're like, hey, Lance, I'm ready to do that. Well, I don't have an app. So anyway, it's just, if that's something you're thinking about doing, I can tell you that I have 800 clients, so I didn't call them all. I've called a lot of the people I've worked with in the past and said, hey, let's act. Definitely called the ones. Jennifer, how many loans have we done in the past 5 years? Our first-time home buyers?
Oh, first-time home buyers?
Yeah.
20, 25.
I think that's probably the last 3 years, but yeah.
Yeah.
Anyway, we've called all them. We're getting them squared away, so I'll hand it off. That's what's going on a little bit in the mortgage world. A little bit of recovery. A lot of activity, highest apps we've had in years.
Yep. So I've talked to a number of lenders, and that's what they were saying. And yes, the war slowed it down. And from my lips to God's ears, this will be done in another 7 to 10 days. So Philip Cantrell, if you aren't following him, you need to be. He's an extremely intelligent person. And one of the main reasons I am still at Benchmark, I always, when people call me up and ask me if I want to leave, I politely listen to them, because you don't know what's out there until you talk. But no one's had anything that is better for me than Benchmark with the way they have things structured. And Philip's brain and Scott Rowland's brains are part of the huge reason that I'm still at Benchmark and very happy with it. So if you're tangent to real estate, I would be following him. He did a Zoom with us on Tuesday. Lance, do you know what the average house price in Franklin, Tennessee, not Franklin County where Garrett and I are, but Franklin, Tennessee, Williamson County? Do you know what the average price is? Average.
1.2.
1.6. 1.6. Insanity. Anyway, the other stats that came out were, whereas you and I have been working a lot with first time buyers, so my niches, like the people that I like to play with and who like to play with me, first time buyers, seniors who are downsizing or selling their homes, post divorce, either when it's first happening and you're selling your house and both people are buying a new house, or when it's a second marriage and they're buying a house together. And then veterans, obviously, because my daughter's the 9th generation of my family to serve, so we work with a lot of veterans. The number 1 and 2 home buyers demographically are Gen X and older millennials. And the Gen Z was low. So I'm very glad that we've been able to get a lot of those Gen Zs. Some of them were younger millennials, but into homes because it's very important that they do. Then we also talked about like the historic, if you go back 75 years, what the average interest rate is. And it was, I think they said 6 plus something. So like when we get down under 6, that's the magic number where the market starts moving. Again, that's going to be coming back when this war, whatever it is you want to call it, that we are currently involved in, settles down, the rates will tick down again. And again, like Mark always says, everybody who's listening right now, if your goal is to buy a home this year, let's be talking now, just like the people who are going to refi, so that when those rates get down, you're at the first flush of going out and you're not being up in the hot market with a lot of buyers. We also have about 4 to 6 months of inventory, which is on that edge of the buyer's market to neutral market. We really want a neutral market. We were talking about home sitting, a 30 to 60 day is not unusual in today's market. Can you still sell your home within 2 weeks on the market? Yes, if you price it efficiently. And what that generally means is history major math. If your house is worth $500,000, you're probably going to want to price it at $485,000 to $490,000, 3 to 5% under what the potential market value is, because buyers know what a good deal is. And then you can get multiple buyers potentially out, not so that you're starting a melee, but so that you get the best offer for both that buyer and the seller, and it's a neutral type situation. Garrett, wanted to introduce you again. Garrett is a lawyer here in Winchester, Tennessee, in Franklin County. I met his wife, Lacey, who is an absolute angel. It's been a few months ago through a ladies networking here. And then was it just last week that you opened your law office on the square, or just off the square here?
Yeah, I believe it was 2 weeks ago. So
Congrats.
2 weeks ago tomorrow. So
congratulations. And then I randomly met your brother last week at a networking thing in Franklin that I haven't been able to get to. So tell us a little bit about what you've done in the last week, or if you want to talk us about opening your law office. And then we want to pester you with questions about wills and trusts and other documents.
I'm going to drop my camera so we can see him bigger and clear.
Okay, cool.
So I'm from Murfreesboro originally, and in 2014, I made the move to attend law school in Memphis. That's where I met my wife, and we moved back to Middle Tennessee right after I graduated, and I started my law practice in Shelbyville, Tennessee, which is where I spent the last 8.5 years or so practicing law with my former law partner, Kelly Wilson. And Shelbyville was great to me, but at the end of the day, we bought a house in Winchester in 2019. And, 8.5 years of making that drive will kind of wear on you. So we decided to put down some roots right here in Franklin County, and couldn't be more excited about that process. People have been extremely supportive. I talked to somebody the other day, so, wow, another lawyer in town. And I thought, well, I'm looking around here, and, I feel like there's room for one more. rural law practice is something that I'm very passionate about. People in small towns and rural communities have different sets of legal issues than what you might find in a big city. So there's a lot of overlap too, but people in small towns have unique problems, and that's something that I feel like God has called me to address. And so I'm a small town lawyer and a small town courtroom kind of guy. When I always tell people this story, when I graduated law school and I was looking for a job, waiting to take the bar exam, I sat down. I didn't know many lawyers at the time. I don't come from a family of lawyers. But I was able to meet some guy that my mom just happened to know from high school. And he bought me breakfast one day and he said, "Hey, Garrett, I was a corporate lawyer, and I was really good at doing one thing, really, really good with mergers and acquisitions and that kind of thing in the business world." He said, "But when I walked into a courtroom, the guys I was most terrified of on the other side of the aisle were small town lawyers, because those guys knew everything."
Yeah.
And that stuck with me. And that's just really something that really hit it home for me. And I thought, I don't know everything. No, I don't know everything, but I'm working on it. And I've got a lot of different practice areas, and I'm proud of that. And, when a client walks into your office, you may have different practice areas that overlap. You may have somebody who has a divorce and a criminal charge. Guess what? I can handle both of those.
Yeah.
People don't want to be told, you're going to have to go see somebody else about the criminal charge. Or you're going to have to go see somebody else about the divorce, right? They want to hear, I can handle that, right? Yeah. And so we got to be flexible in our rural communities. And so that's something that I'm very passionate about. I am here on the square in Winchester now with my wife. She owns Ledgers by Lacey, bookkeeping and tax. And she's been in this space for about a year now, and it was really just the perfect space for a lawyer to move in. So we're up and running, and we couldn't be more excited to serve the people of Franklin County and the surrounding communities.
Yeah, I absolutely love it here. I moved to Tennessee from Ohio in 2000, and I lived over in Thompson Station, Spring Hill for 25 years and was looking probably for 4 or 5 years for a house out here in Winchester, and found mine in 24. And I love it. Small town fits me. It fits my family kind of background and roots. I went to the Builders Association meeting the other day at the country club. I'm excited about the direction that Winchester is going. When you talk about small town things, we've got a lot of farmland, and that's a different kind of will and trust. But just for everyday kind of people, you heard Lance and I say that we work with a lot of first timers. And I always tell them, now that you have a house, you need to be thinking about getting a will. But then there's certain times that you need to trust. So for example, Garrett, my son, I have twins. My twin girls are 28. My twin boys are 23. And when my son Will was 20, he bought his first house. And I said, okay, now that you have this, we need to talk about your, God forbid you die, what do you want to happen to your house? And I said, do you want it to come to my estate and me split it among your siblings? Like, do you want me to be your heir? And he goes, no, I think I'd like my twin to be my heir. And I said, all right, no problem. Well, his twin has some anxiety issues and stuff. So he wasn't working to the high level that Will was financially yet. And I said, you can't burden him with a blessing. So you're going to have to, if you make him your heir, you're also going to have to get a life insurance policy that's enough to pay off that house, and maybe a little extra so that he can take care of utilities and things the first year or two, especially in his grief. And that's the same thing I counsel my young buyers about too. So, and the other thing I definitely want you to address is we have what we call my Mama Jen discussion. When friends or romantic partners are buying a house together, because I always tell them, it's not that I expect your relationship to end, but if God forbid something happened to one of you, let's just say it's a romantic partnership. If something happens to one of you, then you now own that home with their parents, most likely as their next of kin. So you need to have something in writing about how you want to do it, or you need to have it in how you take title. So talk to us a little bit about when you need a will, if there, if you can do it in a nutshell about why you might want to trust. And then also, that situation, if you're buying a house, not married, because if you're married, there's already legal restrictions about how things are going to get split up, given that you're in a legal covenant of marriage.
Absolutely. Yeah, I'm happy to do that. So I guess sort of the first thing that people need to know is that if you do not make a will in the state of Tennessee, the state of Tennessee will write your will for you. That is what's called intestate succession. All right. That is, there's a pecking order in every state, including the state of Tennessee, of what happens to your property and who it goes to when you die. And I can tell you that in practice, probably 75% of people do not write wills.
Yeah.
The vast majority of the estates that I probate are done without a will. And people are coming into my office because maybe somebody didn't put a beneficiary on their bank account, or there maybe they had a house and they've got a blended family with stepchildren and things of that nature. And so what you need to know is, if you do not get ahead of this and write a will, the state of Tennessee will write your will for you, and you may not like the result of how that ends up. I often hear from family members who come in to see me when a loved one has passed away, and they're shocked to find out that yes, I'm the surviving spouse, but I'm not going to be the one who's inheriting everything, because they had children from a prior marriage, and guess what?
That happened to a friend of mine.
In a very expensive and drawn out probate battle. The other thing that I hear frequently is I'll hear this sometimes from husbands when husband and wife come in and they want to do what's called mutual wills. I'll kind of go through with wife first, what she wants in her will, and then we get to husband, and sometimes, not always, but sometimes the attitude is, well, who cares? I'll be dead.
Mm-hmm.
And I hear that a lot, and that's very unfortunate for me, because really estate planning is not about you. It's one of the most selfless acts that you can do. It's about taking care of the people you love after you are gone.
Yeah.
And so
Mark just went through this. Mark, was it your father who passed, correct?
Yeah, I've got a lot of questions, on how to proceed with as a beneficiary in a will that has been written. But based on one of the things the financial coach does is, in my program, we absolutely will spend about a month, almost 2 months, going through and asking the questions about, have you done a will? Have you communicated that to your family? One of the things that I feel like people, in addition to what you just talked about, Garrett, that is missing is people not communicating to the family what is going on with the will prior to them passing. It is so important to communicate this prior to your passing, so that if there are any questions about anything, it's all out on the table, and we go through that. I'll shut up because I know I'm talking a lot, and I always say that, by the way. But one of the things in my coaching program that we do is we walk through building a, quote, legacy drawer, or a legacy notebook, where all of that information is stored. And so that's part of my coaching program. You and I have a lot to talk about, and along with the client pipelines, to where we could, where I would love to bring you in as part of a deeper conversation with clients who are in that state.
Yeah, for sure.
Absolutely. Yeah. I'd second that. What you said. That's absolutely important. So the three key things that we want to talk about here, there's really three key questions when it comes to estate planning. The first one is, who makes decisions if I can't make those decisions? The second one is, who gets my assets when I die? That's the obvious one. And then who handles everything in between, right? Mm-hmm. So a good estate plan will answer those three questions. I can tell you, there are, for the vast majority of people, a simple will is going to be what you need.
Okay.
And I will talk about trust too, because trusts are very unique and flexible tools, but they're not for everybody. Mm-hmm. They work very well in certain circumstances. I think one of the first things that people think of when they're thinking about a will is they just want to put that off. I don't know if it's that people don't want to contemplate their own mortality, or I'll get to that later. But sometimes life catches up to you and doesn't always give you a warning of when the Reaper might come and find you.
Garrett, I had two sets of twins. And also in Tennessee, if you haven't had a will, the state also determines who gets your children or where they go. I had two sets of twins with my ex-husband, and he would not write a will because he said if he talked about it, it was going to happen. And it was so incredibly frustrating and scary to me to live that way. So when we got divorced, one of the first things I did, like we had talked about it, but he wouldn't write it down. But one of the first things I did was write a will when I got divorced so that my kids knew what was going on. I called the people who I wanted to take in charge of them. I talked about where the house was going, but talk us through, if somebody comes in, let's just say it's a young person, not a second marriage. We'll get into that on another episode, but like a young person who's maybe buying their first house with a spouse. Maybe they don't have kids yet, but what are they going to experience?
Yeah, absolutely. So the first stigma that I have to kind of get past is, do I really need one? I don't really have anything yet. I can tell you that if you are married, if you have children, if you own a house, if you own anything of significant value at all, it is extremely important that you do a will. Guys, a simple will is only $250. That's what I charge for a simple will.
Say that again for the people in the back.
Yeah. Wills are affordable. Yes. If you come to my office and you need a simple will drawn up, that's going to run you $250. All right. If you've got mutual wills for husband and wife, $500. But one will is $250, and that's all it takes to save your family from potentially a lifetime of grief for letting the state of Tennessee write your estate plan for you. All right, and so that's the first thing that people need to realize, is that the cost is not astronomical for this particular legal service. People think, well, lawyers are expensive. I don't want to go do it. I don't have the money. Most people can come up with $250 to write a will. And then some of the other estate planning documents that I definitely recommend that you get are also inexpensive. A power of attorney, a durable power of attorney that covers finance, medical, everything you can think of under the sun, will run you $100. And that could potentially save you thousands and thousands of dollars down the road to avoid a conservatorship, which is something I'll get into.
Can I ask you a question about the power of attorney for just a second?
Sure.
Because this is something that I heard that had happened to a friend. Okay. They had a child who was over 18, who was in a car accident, who was not conscious when they went into the hospital. And I believe they were put into a medically induced coma or something like that. But because the parents did not have a medical power of attorney for their over 18-year-old child, they were not allowed to give any directives or anything else, and they weren't allowed to be updated on any information. The doctors were making all the choices because of HIPAA. Is that correct?
Unfortunately, it can be, yes. Okay. So one of the misconceptions that people think that's floating around out there is, well, I'm the next of kin, and so I should be able to make medical decisions for that person when they can't. But that's not always true. Okay. There is a law in Tennessee that allows your spouse to make medical decisions for you. That kind of goes down the pecking order. The problem is the doctors really want to see written permission through a power of attorney, because there can be disputes, right? Some family members may disagree about how to handle a particular situation, or whether they need this, whether they need life support, whether you would want to give them, IV tube feeding or antibiotics in certain situations. These things can be complicated. All right. And so it's best to plan for these things in advance. Something you can do is called an advanced healthcare directive.
Yeah.
Right? It goes through the different areas of, it starts with quality of life. What would you consider an acceptable quality of life? If you were paralyzed from the waist down, would you consider that to be acceptable? If you couldn't recognize loved ones and couldn't have a clear conversation with them, would you consider that an acceptable quality of life? And then the next section on that form goes through treatments. If you had one of those unacceptable qualities that you marked, would you want CPR? Would you want tube feeding? Would you want IV antibiotics if a new condition came up in the hospital? Those types of issues. So it gives direct preferences to the doctors about what you would want. And then the other thing is it appoints a healthcare power of attorney for decision making.
Okay.
So you can appoint your spouse, and you can actually appoint an alternate too, if the primary is unable to step in. So those are very important documents. Again, $100 will take care of this, and you're planning for the unforeseen, right? You're planning for the car wreck. You're planning for the cancer, the thing that life hits you with that you didn't expect.
Yeah.
And unfortunately, I meet with a lot of people who come into my office and they realize far too late that they need that power of attorney, that medical power of attorney. They say, look, my mom or my dad is getting older, and they're showing signs of dementia or Alzheimer's, and I need to be able to handle their affairs. And sadly, most of the time, I have to look at them and say, I'm sorry, it's too late for a power of attorney. Now you're in conservatorship territory, because they are not legally competent to sign a power of attorney at that point. And the shock on their face, that I see, it breaks my heart every time when I tell them about what's involved in a conservatorship. It's going to cost you thousands of dollars. It can be a contested judicial proceeding in some situations. And if it's filed on an emergency basis, I can tell you that there's going to be 3 or 4 lawyers involved in this thing. And that can really, the attorney fees are often coming out of that person's estate. And so that can really, you can really take a hit financially from something like that.
So better to spend $100 to $250, whatever the whole, and I'm sure you may have like a package thing now, than, even 10 hours of 3 attorneys' fees, you're probably looking at close to $5,000.
At least, yeah. I can tell you that in my office, I do conservatorships, and that's a service that I provide for people. And their retainer starts at $5,000, and it goes up from there typically. If you've got a contested case, the sky's the limit on what you might spend on something like that. So I can't stress hard enough how important it is to have a durable power of attorney in place to avoid this type of thing.
So sorry, Garrett, I didn't mean to interrupt you. But you're dipping into an area where I'm interested in asking a following question. I don't want to get you off your bulleted items that you want to cover. And I know everything can't be covered here in this call. But one of the things that I've recently had a client exposed to is an executor of a will failing to communicate to the rest of the heirs and on the status of an estate distribution, not knowing, people all of a sudden just having checks show up unannounced. And the second part of that, number one, what are the the legal requirements of an executor to communicate? Number two, can you speak to the contesting? If one of those, if a sibling is not being communicated with, they don't feel like they're being treated fairly, how can you, even with a clause of a contestment inside the will, can that will still be contested if that sibling feels like they're not being treated properly?
Yeah, those are great questions. If I can kind of break this down. So in Tennessee, there is a statute in the probate code that says the executor of the will, whenever that will is submitted to probate, is required to send each and every one of the heirs a copy of the will. All right. So I often hear people saying, "Oh, what about the reading of the will?" You know, that's something that you see on TV, but it's never been a reality in law practice in Tennessee.
Dude, that's a drama.
Right. Yeah, it makes for good courtroom dramas on TV, the reading of the will, but there is no such thing unless you just want to do that. But the legal requirement is that the executor send all of the beneficiaries a copy of the last will and testament once it is submitted to probate. And then the attorney who's handling the estate is actually supposed to submit an affidavit stating that they have done that. All right. If you die without a will, they're supposed to send you a copy of what's called the letters of administration, right? It's a one-page document that says, I have the authority as the personal representative over this estate, right? So that they know that probate's been opened and things are moving along. Now, you asked about the duty to continually, communicate and keep heirs updated. I can tell you that in my office, when you come in as part of the intake process, I have my client sign an engagement letter that says it is normal for me to communicate with heirs and beneficiaries of the will, even though you are my client, right? And that can sometimes sometimes you can run into issues. Lawyers can run into issues with attorney-client privilege. Where does that stop? Where does it end? But I make sure everybody understands it's normal for me to communicate with beneficiaries of the will to provide status updates and that sort of thing. Now, I can also tell you that in practice, some lawyers are better than others. You may have an attorney who just refuses to communicate with certain heirs about the status of the estate. And maybe the executor who is appointed, doesn't necessarily like some of the other heirs as well. They don't get along, right? That kind of thing is very common. So it can vary greatly depending on who the personal representative is and which attorney is handling the estate, right? I can tell you in my office, it's normal for me to send out letters and status updates and that kind of thing when I have an estate that's open for a really long time, right? It just kind of calms the room a little bit when people know the status of where you're at and what you're doing, right? And what's going to take to get it wrapped up. So that's kind of the reality. Now, heirs who feel like they are being left out in the dust always have the option of going and hiring their own counsel to represent them in the estate. And I have done that for folks on occasion. And I've had other heirs that, have done that as well, not because they felt like they weren't being communicated with, because they didn't really get along with some of the other people. But you always have that option as an heir to the will, but you're not the executor. You can go and hire your own counsel to represent your interests. I think the last thing you asked about was those no contest clauses in the will. So I can tell you that that's called an interorum clause in a will, and courts will give those legal effect if they are properly drafted. Here is where those really come into play. All right, and I've had people request on plenty of occasions to put these in their wills, and I'll do it. So basically what it says is if you contest this will, you don't get anything under the will. All right, so now, you might want to think long and hard if you are a will beneficiary. So you stand to inherit, a house or some assets or whatever the case may be. But you think, there's other people in this will and I'd like to knock them out and take everything for myself. Well, guess what? A court will give that clause full effect. That's a valid will clause in the state of Tennessee. Now, here's where it doesn't deter anybody from filing a will contest, right? Is when you're not in the will, right? But you would otherwise have legal standing to challenge that will, okay? And legal standing is something, basically, you would have to be what's called an heir at law. So if that will were thrown out, you would be the person inheriting the estate. So in that situation, you've got nothing to lose, right? And so a will contest is more likely to be filed in that particular circumstance.
Very good. Awesome. I appreciate you diving into that. I think that's, a lot of valuable information towards a will. And I just appreciate your knowledge in all of this, Garrett. It's not an easy topic. It's not an easy topic that I deal with in my coaching program for people. But it is so important. I cannot echo that enough, that getting these things in place is in communicating to your family what makes up the assets and and so that any questions can be answered while the person is living. Is so important, so deeply important.
So I have a question for you. You said that there were 3 stages. Is the first one the power of attorney, and then the will, and then the executorship? Is that the stages you were referring to?
Yes. So the power of attorney covers situations. That first question that I discussed is, who makes the decisions if I can't, right? Okay. A power of attorney allows you to legally step into somebody else's shoes and make those decisions, whether it be financial decisions or medical decisions. Mm-hmm. A good general durable power of attorney. Durable means if you are incapacitated or you can't make decisions, that power of attorney is still good, right? A non-durable power of attorney is not good in those situations. What people really need is a durable power of attorney.
Okay.
And so that's so important. Again, $100 will save you just a lifetime of misery if something happens. And so, that goes to that first question there.
Okay. And then the will is obviously when somebody has passed, and then the executorship is after. I have about 3 questions that I wanted to ask you.
Sure.
My understanding, unless this has changed, is that real estate is handled separately from personal property in the state of Tennessee. So in your will, should you have somebody, should you make it clear that, I have 4 kids, that this child is the one that's kind of responsible for dispersing everything? And the reason I ask is I have a friend, and she's a realtor, and her aunt died, I think, without a will, but she had 30 cousins who all had to sign off on the sale of the property because they were all co-heirs.
Yeah. That's a very unfortunate time.
It was for everybody.
I unfortunately meet with people like that all the time, where there's so many heirs, and a will would have saved them so much of a headache. And now, I met with some folks a while back, and they brought in, and the last deed to this house that had been done was in the 1800s. They pulled out the original deed, and I said, "Oh no, I cannot probate this estate. You're going to have to go see a real estate attorney about quieting the title on that piece of property, and that's a separate lawsuit you've got to file, and there's a whole other thing involved." And I'm sorry, I kind of lost my train of thought. What was the question again?
So real estate is handled separately from personal property. Yes. So you have to address that in a will specifically. That's right.
So in the state of Tennessee, we have real property. It is treated differently. You're right. So believe it or not, some people are surprised to find, and even some attorneys are surprised to find, that real property is not treated as part of what's called the probate estate. Whenever you probate your will, real property immediately vests in the heirs. in whoever your heirs are. Okay. So your heirs, might be determined by the state of Tennessee if you don't have a will, or if you've got a will, you name your heirs in the will, right? But legally speaking, real property immediately vests in your heirs upon your death. The problem is you need evidence of that, right? A title company is not going to accept the fact that, well, it just vested over here in my brother Bob, right? You need proof of that. So that's where probate comes in. And so the other thing that people are kind of surprised to know about is because real property is treated that way, it vests in your heirs. The executor only has, by default, limited authority over that real estate whenever they probate the will. However, I think it's in the first couple of months, the first 4 months, they can do some things like pay the utilities, kind of upkeep the property a little bit, but they don't have full authority to just do whatever they want to with that property. That can be fixed, however, with language in your will that actually makes your real property part of your probate estate.
Yeah.
That language has to be drafted and put in there by a lawyer because courts look for it. It's very specific magic language that you put in your will. And it goes something like this. I don't have it right in front of me, but it says, I give my personal representative full authority over my real property, and I direct that my real property be administered as part of my probate estate, subject to the control of my personal representative, right? Okay. My executor. And that gives that executor full authority over the property, which is oftentimes what they need.
Yeah.
So this is something that I often include in wills. I don't always. It depends on the situation, right? If you've got just one person inheriting a house, well, you don't really need, you don't really need that language. But it never hurts to have it in there, okay? Because the only other situation where a judge is going to treat that real estate as part of your probate estate is if you've got what's called an insolvent estate. That means your debts exceed your assets, right? Mm. Creditors come in, say you've got credit card bills, unsecured debts, whatnot, and, that exceeds the value of your real and your personal property. Then you've got a situation where the executor actually has a duty, a legal duty, to file a petition with the court to sell that real property and satisfy the debts. And kind of come up with a plan for who gets paid first. That's where a probate court can kind of turn into something that looks more like bankruptcy court. You hopefully you don't wind up in that situation because it's never one that you want to be in. But that is the only other situation, unless you have that language in your will, where a judge is going to treat that real estate as part of your probate estate.
Okay. Now I have two other questions. Well, and then like a third category that we'll have to talk about on another day. My understanding within the last year, I learned this, and I would like you to clarify for both real estate and bank accounts, there is no transfer on death in Tennessee.
So it kind of depends on when you say transfer on death. I think what you're really referring to is, do you have to do anything to change the title to
no, I mean, like my other half, he inherited his parents' house and bank account. And so when they were aging, they went up and they did it so that it transferred on death to him without doing a probate. They had wills and things too, but it transferred. And my understanding from talking to a friend who needed some questions about that is not, you can't do that. Like my parents are 85. Can I go and have them put their bank account, not add me to it, but add me to it when they die? Like, can you talk about that a little bit?
Absolutely, you can.
Okay.
This is something that I tell every client because people are very surprised to realize that in most situations, your bank accounts, your financial accounts do not pass through your estate when you die. You can put them in your will, but if you place a beneficiary on your bank account, say your checking account, beneficiary can also be placed on, an IRA, a 401k, any type of financial account, really. That is payable on death to the beneficiary. As soon as you die, you do not have to go and probate your estate down at the courthouse in order to get access to that money. All the beneficiary has to do is go down to the bank and typically show them a copy of the death certificate and a photo ID to prove that they are who they say they are, and they cut them a check right there on the spot.
Now, if you're married and you have a separate account that your spouse is not on, you would need to do that in that situation as well, correct?
Yes, and I always recommend, as part of a good estate plan, that you keep your beneficiary designations up to date, because people forget to update these things, and all of a sudden, it's like, oh, my mom's still on there, and I got
your ex-wife
now, or my ex-wife. It works. So that's extremely important. The other types of things that will not be treated as part of the probate estate are like joint bank accounts. If you got a bank account with somebody else, those are payable on death to the survivor, and any kind of jointly titled personal property as well. Real property is a little different, but when you're talking about, I want to avoid probate, it starts with making sure you've got beneficiary designations on all your financial accounts, and that those beneficiary designations are up to date and how you want them to be.
That what you just talked about is one of the most important things that I work through with couples when it comes to simplifying their finances, and that is building joint accounts. Because one of the things, and Garrett, I know we're 51 minutes in right now, but one of the things that is a problem is in the case of an accident, and someone is incapacitated, a spouse is incapacitated, money that is needed to survive or money that is needed to take care of whatever situation they're dealing with at the time, without having a joint account, without that person being on the account of the spouse, they can't. The spouse is going to find problems going to that bank in order to get access to the funds. That's one of the most important consequences of not having joint accounts. And I cannot stress that enough. It's just, if you're not on your spouse's account, you can't get access to that money.
Yeah.
That's absolutely right. And for some reason, the concept of joint accounts makes some people uncomfortable. I can tell you this: if you don't want to do a joint bank account, this goes back to that, have that durable power of attorney, because then you can access that money, that person's money, from their separate account. You just have to take the durable power of attorney down to the bank, and they'll put you on there as POA. Yeah. So that's yet another situation where a POA saves the day.
Do you have to bring something? Do you have to bring something with you to show that they're incapacitated?
So that kind of no. The default is no.
Okay.
You can draft your power of attorney in such a way as to provide that there has to be proof of that. I've done it before where it's like, okay, yes, but only if two doctors say that this person is not mentally well or incapacitated or whatever, and that provides a safeguard, right? Maybe that's with I need a power of attorney, but I don't know if I 100% trust this person to be my power of attorney. In that type of situation, the attorney might draft it like that. But otherwise, for most people, if it's just your spouse or somebody that you truly trust, a general durable power of attorney is just going to cover all of that, and the bank's not going to ask you any questions about it, right?
Okay. So the things we need to do today, we need to have beneficiaries on our bank accounts if we don't have a joint account. And even if we have a joint account, I would assume we need a beneficiary if something happens to both.
Yes.
Yep. And that's when I say bank accounts, I mean all financial type accounts, IRAs, whatever they are.
Yes.
Then we also need to make sure that we have a will and that it's updated to the current address and the current people that we want to have it. Garrett can do it for you for $250. We need to have a durable power of attorney for medical and general or whatever it is, and those are $100. Call Garrett. We've had his number scrolling across really quick because we are pushing up on the limit. We kind of try and keep things at landlord tenant disputes, is that something you handle? And if not, can you connect me with the real estate attorney that we might want to have on sometime?
In some situations, yes, I have handled landlord tenant disputes. I only, in my practice, I only do it on the landlord side. If you are a tenant who has issues with their landlord, I tell everybody to contact legal aid.
Okay.
Legal aid of Middle Tennessee and the Cumberlands. Those folks specialize in that kind of thing. And so if you're a renter and maybe you can't afford the legal fees, that they are the first line of defense for helping people out in that situation. For landlords, if you have somebody that you need to do on or things like, I have represented landlords in the past. That's not a primary part of my practice, but it is something that I offer.
Okay. And then can we have you back on to talk about like prenuptials for people who are having first marriages, second marriages, all those things? I think we need to talk about that. And I'm sure we'll come up with other things that we might want to have you back on. Mark, what do you want to add?
Yeah, one last question I had really quickly. So can anyone contact you from outside of Tennessee, or you just, or is how does that work? Can I, if I live in Texas, can I enlist your help for a Texas will?
Sure. So the quick answer is I am only licensed in the state of Tennessee to practice law. All right. There's some attorneys that are licensed in multiple states that can handle matters in multiple states. I always tell people, whether this costs me business or not, hire local talent, hire somebody from the area that you live in, where your legal issue is. That person is going to know the legal system in that particular jurisdiction. They're going to know the judge. They're going to know the opposing counsel. They're going to know how things work in that particular courtroom. For estate planning, that's not always the case. You just need somebody in that state that is competent to do, wills, power of attorneys, that kind of thing.
That brought me one last question. I had a friend whose father moved here from Florida. They owned nothing. They had some personal property. And there was an issue when he passed that his will was not valid because they had moved him to an assisted care here when he passed. So when you cross state lines, that invalidates your will?
Not necessarily. So in Tennessee, we'll recognize a will that was done out of state if it was done in accordance with the formalities of how you execute a will in that state. And so Tennessee will recognize foreign wills, but it is always a good idea when you move to a new state to see a lawyer in that particular state about your will and whether that will is still doing what you want it to do. Because chances are, if you've moved to a new state, you've acquired new real estate, you've made some major life changes, it's time to relook at that will. All right. And so talking to an attorney in the state that you just moved to about your estate plan, absolutely, that's imperative.
All right, perfect. Lance, did you have any questions?
No.
Nope.
Great presentation.
Yeah, we really appreciate you coming on today and letting us pick your brain and share with people what they need to kind of get in place, and that it's very reasonable. It's not, some ungodly amount of money. People blow more than that every month.
Look, for the cost of 5 pizzas.
Yeah.
That's right.
Yeah.
Depends where you're at, Mark.
I'm always coming back to the fast food and convenience. I think that's a theme for me.
Yeah, for sure. Well, we'll wrap up and cut off, and then we'll see. We'll join again next week. I think we should have Lacey come on sometime too to talk about the financial aspects of what you need to be putting in place and how the best things on inheritance and things like that. So I'll talk with her as well.
Absolutely.
But I also like the idea if she's in bookkeeping and stuff like that. That would be a really good topic for small businesses that are out there listening. Love to have her as a guest speaker as well.
I'm sure she'd love to. Just reach out to her. I'm sure she'd be happy to do that.
Perfect. I'm going to cut the recording, but don't go anywhere yet.